Let us assume that we are in a proper court, a court that has a valid basis for asserting jurisdiction over the custody issue. How will that court make the determination? The answer is simple. The court, in disputes between biological parents over custody of the child, will make the determination by invoking the best interests of the child standard. The best interest of the child standard. That is a very important, indeed a central concept in most family law issues concerning children. Let me, perhaps in the interest of thoroughness, or perhaps in the interest of reflecting some of the case law involving best interest, give you some of the kinds of issues that have been deemed relevant to calculating the best interest of the child. The first thing that I should say in this regard is that there are no gender presumptions concerning child custody. In former years, there used to be a presumption known as the tender years presumption, under which children of young age were almost presumptively or automatically given to the mother as custodial parent. That presumption is no more. It doesn't exist. It is of dubious constitutionality. Although I should tell you that some states have effectively recreated the tender years presumption through the back door by arguing that the primary caretaker should have custody of young children because it's assumed to be in the best interest of young children to be with the primary caretaker. Well, in the America of the 1990s, the primary caretaker continues to be, for a very large number of couples, the mother, so the effect of the primary caretaker standard is in many respects to recreate tender years. Now, given no gender presumptions, what are some of the variables that guide us towards the best interest of the child? Well, first, the wishes of the two parents. Certainly, if one parent says, I don't want the kids, I hate the kids, it's a good clue that that parent will not make a suitable custodian. Second, we will be interested in the wishes of the child. We will be interested in the wishes of the child, and our weight of those wishes will increase as the child gets older. If a 15-year-old says, I can't stand my father, we fight all the time, I want to be with my mother, that will be highly influential. In many jurisdictions, the wishes of the child will be elicited in a confidential interview in the judge's chambers, not in open court, to spare the child embarrassment, and indeed, I suppose, to spare the parents a certain amount of embarrassment as well. The court will also consider the relationship of the child with the siblings in the family and with other relatives. If there is a strong bond between the child and a particular grandparent, that may influence awarding custody to the parent who is the blood relative of the grandparent in question. The court will look at the child's adjustment to his home, to his school, and to his community. If the child is very much active in school activities, if the child is popular in school, if the child would be traumatized by being forced to change schools, that may militate in favor of a custody award one way or the other. The court will look at the mental and physical health of all parties involved. Perhaps one party has a drug problem. That may indicate that they are an unsuitable custodian. Perhaps one party is infirm in some way. That may make it difficult for them to be a custodian. Maybe the child has a health problem and therefore needs to be placed with a particular parent who has a special skill in coping with that health problem. There has been some controversy about the role of religion in interpreting the best interest of the child standard. The courts sometimes say that they will consider religion if the religious belief system of one of the parents poses a threat to the health or well-being of the child. If the belief system of one of the parents poses a threat to the health or well-being of the child. That, of course, is most visible or most salient in those faiths that refuse certain types of medical treatment or refuse all types of medical treatment whatsoever. For instance, one parent may belong to a faith that does not permit blood transfusions, or may belong to a faith that does not permit the use of medical care at all. The courts sometimes say that that can be taken into account. But even in those cases, the courts tread with a great deal of caution because of fear that they may run afoul of First Amendment considerations concerning free exercise and because of a desire to avoid making value judgments about the superiority of different religions. If you see that as an examination problem, as a bar exam problem, or in practice, you would want to weigh both sides of the coin. The jeopardy to the child on the one hand, but the parent's free exercise rights on the other. Race is another controversial issue that may arise. We may have a situation of an interracial couple, and then we may have a situation where the child's custody is being debated. The child may appear superficially to belong to one or another racial category. Can the racial category be used to place the child with the parent who most resembles the child? The Supreme Court has suggested that this is an impermissible consideration. The Supreme Court decided a case called Palmore versus Sidati, and in that case it held that race cannot be used as the sole factor in a custody dispute. It is ambiguous after Palmore whether race can be a factor as opposed to the sole factor, but the thrust of the opinion is that reliance on race is a dangerous constitutional way to proceed. Finally, there's the question of the morality of the parents and the degree to which that should influence the custody decision. The Uniform Marriage and Divorce Act says that moral issues unrelated to the welfare of the child should not be considered. For instance, take the issue of adultery, take the issue of extramarital cohabitation. Let us say since the divorce, one parent is now living outside the bonds of matrimony with someone, or let us say that even during the divorce they have been the adulterer in the presence of the child. If the parent, because of the adulterous relationship, is neglecting the child, is lavishing so much attention on the paramour that the child is being left to his or her own devices, then the adultery becomes a factor bearing on the best interests of the child. But if the adultery is conducted in a discreet fashion, if the adulterous liaisons occur when the child is asleep, if there is no parading around or visible exposure of the sexual nature of that relationship, the Uniform Act approach, and the approach of many states that follow it, would be to ignore that as a factor in the custody decision. Bear in mind, however, that other states do consider that as a moral blemish on the record of the adulterous parent, and those states may deprive that parent of custody. There is a split here. The Uniform Act takes the view that it's irrelevant. Another related problem is the issue of whether or not persons who are gay or lesbian may obtain custody of their biological children. Courts increasingly are moving to the position that gay sexual orientation is not a per se disqualification, and that therefore the best interest of the child will be analyzed based on a fact-specific analysis of the behavior of the particular individuals. However, there are courts, many of them still in influential states that have large populations, that will in effect deny custody virtually automatically to a gay parent, or at least impose a presumption against a gay parent requiring that parent to show no adverse impact. This is obviously an area of the law that's subject to change as social attitudes change. It's an area of the law that you should watch, and one might expect that there will be movement in this direction, furthering the trend of treating gay parents substantially equivalent to heterosexual parents. Finally, a small point about the best interest of the child standard and the dispute between the two parents. If there's a reason to believe that one of them is more likely to facilitate visitation by the other, that party will be deemed, in some sense, a preferable custodial choice. The parent more likely to facilitate visitation is more likely to get custody. Once the court goes through the best interest analysis and makes an assignment of the child to a particular parent, the other parent is entitled to visitation. Visitation is a very strong prerogative of a biological parent. It is almost never denied, and would only be denied if visitation would pose some kind of serious jeopardy to the health or welfare of the child. If the court is concerned about the safety of the child, but feels that visitation should still be allowed, it can order supervised visitation, in which some third person will be in attendance whenever the non-custodial parent is with the kid, perhaps a social worker or some other child service-oriented person. Can other parties in the family secure formal visitation rights? The answer is yes, if they can demonstrate that it would serve the best interests of the minor. Grandparents, uncles, siblings, perhaps siblings who are now beyond the age of minority, those parties can all secure visitation as well. Now, that is the situation that we confront when the two parents are contesting against each other for custody. What happens if a non-parent seeks custody? What if a grandparent or an aunt comes in and seeks to wrest the child away from the parent? In these circumstances, in a sense, there is a departure from the best interest of the child standard. Because in these cases, there is a strong presumption in favor of the parent. That strong presumption in favor of the parent means that effectively the non-parent seeking custody has to show that the parent is unfit. It's not enough that they show that they could do a better job. It's not enough that the aunt comes in or the next door neighbor comes in and says, look, I have more education, I have more financial resources, the child interacts with me very well and likes me, the child has arguments with his biological parent, I want custody. That's not enough. You're going to have to defeat the presumption that the parent is the appropriate custodian, and you're going to have to do it basically by showing that the parent is unfit. Part of the reason for that approach is not just state arbitrariness, but an actual concern that any other rule might violate due process considerations concerning familial privacy and concerning parents' rights to be with their children. Two other points about custody awards that I think we should take a moment to explore. First, the right of the custodial parent to travel, to move away, to leave the forum state. Most states will say that the custodial parent may not leave the state absent good cause. They have to show a good faith reason to move, and that the move itself would not undermine or be inconsistent with the best interests of the child. Part of the reason for that is because such a move will make visitation by the non-custodial parent considerably more difficult. It also involves a disruption in the life of the child. So that one of the burdens of winning a custody battle, one of the burdens that comes with it, is an inhibition or a limitation on your ability to relocate. The other point that I wanted to mention to you is the possibility of shared custody. Shared custody is, in effect, a compromise situation in which each parent is given the right to spend a certain substantial portion of the week or the year with the child, and each parent is given a role to play in making decisions about the child's upbringing. There is a trend to shared custody where it is workable. Shared custody is considered to be in the best interest of the child because it keeps the bond between the child and both parents more forceful, more vivid than would be the case in a sole custody or an exclusive custody award. The precondition for shared custody, however, is that the parents are willing and able to cooperate and that there is not a high degree of hostility between them. It is plainly unworkable to award shared custody in a situation where there is a degree of marital hatred such that the parties will constantly be at each other's throats. So that is what you need to know about custody, at least about initial custody awards. What about modification of custody? Can a custody award be modified? Well, the traditional rule allowed modification of custody, but required the party applying for modification to prove a significant change in circumstances. The rule requiring a significant change of circumstances was based on the notion that stability in the circumstances of the child is very important, and therefore we ought not to disturb the existing custodial arrangement unless there's been some consequential change, some significant change in circumstances. Lately, a number of states have departed from this standard. New York, Pennsylvania, and others. In this sense, they have said that there is no need to identify a particular event that has changed. There is no need to come in and say, the custodial parent has started using drugs. Or no need to come in and say, the child has shown a great musical talent and I am a musician and my ex-spouse is not. There is no need to point to a particular factor. You need only demonstrate that the best interest of the child warrant a readjustment of the custodial arrangement at the present time. In effect, the focus is no longer on changed circumstance. The focus is on the best interest of the child. Now, having said that, that may not be as much of a change in the law as it seems. That's because the current custodial parent is sure to argue, when the modification is applied for, that the modification is not in the best interest of the child, because stability is important. So the stability factor will still be argued. But there is now no longer a requirement in these states that follow this new rule of a showing of significant change of circumstances. Let me, before I move into our last two topics, say one final word about the best interest of the child standard. Issues concerning children can present themselves to family law courts in a wide variety of settings that do not technically involve custody disputes. There can be also custody disputes of a type that we have not discussed. For instance, we've not discussed foster parents. There can also be situations in which a child is seeking a certain kind of permission to have surgery performed without the permission of parents. Perhaps the child wants to have cosmetic surgery done and has made application to the court through a guardian. Perhaps there will be some kind of issue concerning the child's desire to adopt a certain name or participate in a certain kind of athletic program. One can imagine a large number of issues involving children that may be presented to courts. And what I would say about all of those issues is that if you can remember the magic phrase, best interest of the child, you will always analyze those issues correctly, because all of them are determined based on the best interest of the child. Whatever the issue may be, that's the standard you want to use. And to be quite blunt about it, that standard is something of an open sesame. Once you have invoked it, you can in effect bring in any conceivable logical factor that bears on the facts and use it to argue the best interest of the child. Well, with that out of the way, let me turn to our penultimate subject, the subject of termination of parental rights. Termination of parental rights can be either voluntary or involuntary. Voluntary termination of rights is really quite simple. It is, I think, most commonly referred to in everyday speech as, quote, giving your child up for adoption. The precise procedure varies from state to state, but basically both parents must give consent in writing indicating that they no longer wish to be considered parents of the child. In some states, there will have to be a form of judicial hearing, and then there will be a turning over of the child to a state social services agency, which may keep the child in a facility that it runs, or which may place the child in foster care. Typically, this voluntary relinquishment or voluntary termination occurs at or near the time of the child's birth. This is not something that you typically do when, upon returning from Disneyland, after a miserable 7-hour drive with your child in the car, you throw your 9-year-old out the car door and voluntarily relinquish your parental rights. Generally speaking, you do this when the child is a newborn. The other mechanism is involuntary termination of parental rights. This is, in effect, a state taking the child away from the parents. Obviously, this implicates considerable constitutional issues. It implicates constitutional issues because it represents a direct state interference in the privacy interest of families and in the rights that families have, the fundamental rights that parents have to raise and keep their children. The involuntary termination of parental rights is never determined based on the best interest of the child. The parent may be quite a mediocre child, and the child may suffer from being with this mediocre parent, but we do not look to the best interest test. Instead, the state must prove parental unfitness. Typically, that unfitness can take two forms: abandonment or neglect. Abandonment is walking away from the child. Now, usually that will apply to a non-custodial parent whose parental rights need to be terminated to free the child up for adoption. Let's say we have an out-of-wedlock child. Let us say that we have a man who's been adjudicated the father in a paternity suit. Let us say that he's also been obliged to pay support under an order as part of that paternity proceeding. Let us say that he never visits the child. He never makes his support payments. He is in contempt of court. He never communicates with the child. He is basically dropped off the face of the earth. That constitutes abandonment, and his parental rights can be terminated. The other ground for termination, neglect, represents, of course, some of the most melancholy business of the family law courts. These are situations in which a parent fails to provide adequate food or clothing or medical care to the child, or indeed those circumstances where there are affirmative acts of child abuse, sexual molestation, physical injury, perhaps beating, perhaps leaving the child chained to articles of furniture or what have you. In those situations, again, the state can come in and demonstrate the neglect as a grounds for termination of parental rights. In all of this, because of the constitutional concerns that we confront, the state must prove the underlying facts by clear and convincing evidence. That is constitutionally mandated. Supreme Court decided that in 1982 in a case called Santosky versus Kramer. Interestingly enough, however, despite the importance of this proceeding to the lives of the families, and despite the constitutional liberty interest in maintaining your children, there is no right to counsel for indigent parties found in the Constitution, at least according to the courts, and consequently no duty for the state to appoint counsel if the parents are indigent. Once we have a child who no longer has a parental relationship, filial relationship with any adults, that child is free and available for adoption. Adoption has traditionally been an area where there has been a large degree of variation from state to state. In 1994, a new Uniform Adoption Act was promulgated. It has not yet been widely adopted, but there is a good reason to believe that it will be, and therefore over the next several years we might hope to see some greater uniformity. Notwithstanding the lack of uniformity, let me sketch out, at least in rough outlines, the general rules concerning family law, adoption proceedings. First, who can adopt? Any adult can apply to adopt. In addition, minors can adopt if they are married to spouses and the spouses have children. For instance, let us say a 17-year-old girl marries a 24-year-old guy who has a 2-year-old kid from a former marriage. The 17-year-old wife can adopt that 2-year-old child even though she's a minor. Otherwise, you must be an adult to adopt. Who can be adopted? Anyone who doesn't have parents. That includes not only children, but adults whose parents have died. You can adopt, one adult can adopt another adult. However, there's a limit on that proposition. The purpose of the adoption must be to form a genuine parent-child relationship. Now, that parent-child relationship may be desired for reasons of estate planning. It may be desired for reasons of comfort and care to be provided to the older of the two parties. But it has to be a genuine parent-child relationship. There is at least one case in which two gay men were living together and being denied the right to marry. One of them applied to adopt the other. The logic was that if they could establish a parent-child relationship in the eyes of the law, they would be insured of the fact that in the event one of them became incapacitated, the other could make decisions. In the event that one of them died intestate, the other would inherit, and so on. Nonetheless, the state refused to grant the adoption on the grounds that they were not seeking to create a bona fide or genuine parent-child relationship. Now, assuming that I've got an eligible adoptor and an eligible adoptee, what happens next? What typically happens in most states is that there will be an investigation of the suitability of the prospective adoptor by some kind of state agency. There will be visits and interviews. There will be an inquiry into the economic, social, and psychological background of the adoptor. The court will then conduct a hearing based on the information that it has about the potential adoptor and the information it has about the child. In determining whether or not to grant the adoption, the court will rely upon, and there's no surprise here, the best interest of the child standard. In some states, in addition to the best interest of the child standard, the court will require the consent of the child, although normally that is only done if the child is over a certain age, like 12, and that is not universal. What's the consequence of an adoption? Well, adoptions are final. They cannot be modified, they cannot be undone, and they create the relationship of parent and child for every purpose we have discussed. An adoptive child is entitled to support. An adoptive child is entitled to inherit. An adoptive child is entitled to recover money for wrongful death if the parent gets hurt in a tort. For all purposes that the law recognizes, adoptions put you in the position of a natural child. That, I think, constitutes a fairly good survey of most of the major doctrines of family law. But the nature of family law is that no such discussion as this can be complete and cover every topic taken up in these courses, because there is a really endless variety of problems that most family law courses attempt to address. This is plainly one of the most dynamic areas of the law, and therefore I hope that this has provided not only some help and background and assistance, but perhaps even an incentive to some further inquiry and study on your part. Thank you very much.